Compensatory can also be called as actual damages. General damages cover the loss directly and necessarily incurred by the breach of contract. We calculate the compensatory damages depends on the type of contract that we have breached and the type of loss that has incurred. Good morning and welcome to the session 6 in Unit 2 Commercial Law, where we are going to talk about the remedies for breach of contract. Now, what is this that we are going to talk about as remedies all about? The moment I use the word remedies, it is like actually going forward and covering up for your mistake. Taking up that factor, saying that yes, I have committed a breach, I have committed a mistake, I have done a violation, but let me go back, correct it. So what is the correction procedure? How do we correct when a breach of contract happens? So let's go and look into it. Starting with, there are several remedies for the breach, such as award of damages, specific performance, when we talk about the rescission, the restitution, and the courts of limited jurisdiction, that is going into picture. But the main thing here is the award system. Now, what happens? Why am I talking about the award? What kind of award am I talking? Award of damages. At the end of the day, there is nothing bigger than money. That's what business teaches everybody in this world. Business tells you that money is everything, and the sake of money we get into contract, we get into business. So if you are going to violate a contract, at the end of the day, please compensate me for the loss that I've gone through. And that is what I am expecting as a part of breach altogether. So the court also goes with what the business says, and the court says that please pay back the damages. So that would be the biggest punishment which would be given for the breach of contract. And of course, by paying back the damages, you are settling the scores altogether. So that's why I would say the remedies for breach of contract is very, very important. Now, because specific performance and rescission are equitable remedies that do not fall within the jurisdiction of the magistrate court, they are not covered because they are not going to be covered in this session at all. Now, let's go further and try to understand this factor very, very clearly. Now, there are two general categories of damage that is being awarded for the breach of contract claim is proved. Suppose there is a breach of contract that happens. There is a person who comes back and tells that, sir, people have violated the contract. You have gone against the contract. So I am going to claim a breach against you. I am going to claim a damage for this particular activity. So how can you claim? The first thing is called as compensatory damages. Compensatory can also be called as actual damages. So this is what we need to understand. It covers the loss of non-breaching party incurred as a result of breach of contract and the amount awarded intended to make the good or replace the loss caused by the breach. Now, what happens is that the word compensatory is not just about the money factor that we are going to talk, though it is going to award money to the person who is affected. But then the compensatory actually means that you need to put the things back in place. They joined a contract because in good faith and good trust. Now, two parties are coming forward and they are saying that, yes, we are going to join hands and start a business. But tomorrow, if there is going to be a breach of contract altogether, there is going to be a violation. We have seen so many cases in India regarding this. There have been several times that when one company is being accused by another company for the breach of contract, for the violation, and all those factors. So now what happens is that the company or the contract, the person puts a charge against the other saying that you need to compensate me back. You need to put me back to cover up the loss so that I am in a good position. But if I'm not doing it, if I'm not understanding it, if I'm not taking it forward at all, if I just say that, okay, things are fine, I'm not going to listen to you, I'm just going to take it forward kind of thing, then there is going to be a challenge. So what happens here is that we try to provide the money not only to just solve the case, but to bring back the affected party to normalcy. So suppose because of violating the contract, the damages are going to be worth say 5 lakhs. The 5 lakhs is supposed to be paid to the affected party in order to replace the actual loss cost. Because the loss that is caused is now worth about 5 lakh rupees. So that is the amount that person is claiming back. So this is actually what we are trying to put into it, is that the loss which is actually caused, the loss which will actually put that person into a serious situation back. So that is why we want this particular compensatory damages to come back. Now, the next thing is that the general damages. What is this general damages all about? General damages cover the loss directly and necessarily incurred by the breach of contract, are the most common type of damages awarded for the breach of contract, which means to say that direct loss, moment I break a contract, what is the immediate repercussion of it? What is the immediate impact of it? The immediate impact is that there is going to be some loss, there is going to be some damage. So let me just cover it up. So when I say the word general damages, this means it is implied, it is immediate, it is direct in nature. So that's where we are coming in to say that it will cover the loss directly. Whatever is going to be the loss because of that particular incident, because of that particular breach of contract, that is going to be covered as a part of it. So that is why we call it as breach of contract. That's very, very important for all of us in terms of understanding. Now, the next thing is that Company A delivered the wrong kind of furniture. I'm just putting an example for you. A wrong kind of furniture to Company B. After discovering the mistake later in the day, Company B insisted that Company A would pick up the wrong furniture and deliver the right furniture. It's a very, very common thing. Right from Amazon started this factor called as that, goods replacement within 30 days kind of thing. Probably, this is something which has been existing for a very, very long time altogether. Moment a company delivers something which is not being told or something which is not being correct, now the other company will definitely go back and say that, sir, please take back your goods because this is not what we wanted. We wanted something else and you have delivered something else, so please take it back. We don't want this furniture at all. Now, Company A refused to pick up the furniture and said that it could not supply because it was not in stock. Company B successfully sued for the breach of contract. It is possible. The answer is yes. Why? Because when you signed the contract, you would have written very clearly that this is the kind of good that I am going to supply. Now, the contract clearly states about the word called as specifications. So, when you are signing up the contract, you would have signed on certain specifications. You would have told, these are the dimension, these are the size, these are the factors under which I am going to supply the goods to you. Now, when you are not able to keep up to your promise, when you are not able to fulfill your words, automatically what happens? That's a breach of violation. So the other company will take this as an opportunity and sue you back, saying that you have not kept up your word. So this is typically a breach of contract. Now the Company A might go back and tell several reasons stating that, sir, it is out of stock, I don't have the necessary furniture, I might supply back to you within a month, within a week, but that is not accepted. Why? Because while signing the contract, the contents of the contract clearly specify, clearly mention that I need this particular kind of furniture, and when you have delivered the wrong, it is up to you to replace it back. Now, moving further, the general damages for this breach could include, these are the factors: refund in start of any kind of things to the Company B. You have to start giving the refund altogether to the furniture where what has been given. So you take back that furniture and refund the money back to Company B, which has to be given. Reimbursement of any expense Company B incurred. Now you're going to talk even about the reimbursement that is included. Payment for any increase in the cost Company B incurred. Payment for increase in cost for the Company B incurred in buying the right furniture or the nearest equivalent from another seller. Now look at the way the general damages can be quoted. First thing is a simple refund. What we all do with an Amazon or with a Myntra or any of those apps, I don't like this good, so I'm giving back the goods to the seller and I'm saying, please refund my money back. Fine, fantastic, agreed, he will again credit back your account. That's the simplest way of ending the story. The other thing is that you also have to give me a reimbursement because there are certain costs incurred by me. I had to run up and down to get this particular thing. There's a cost, there's a logistics, there are certain factors that are involved with it. So reimburse that factor also. The third one is that because you delayed, now the actual cost of the furniture has gone up. So you will pay me for the actual cost plus the damages so that I will go and get this furniture from somebody else. So this is where exactly the general damages mean to say. Why? Because you are directly compensating for the loss, directly compensating for the mistake that has happened. That is what we want you to understand. It is nothing complicated at all. It is nothing severe at all. You have not done a very big serious crime. The only thing here is that since you have not kept up the words, it's up to you to just refund it or just give him a replacement altogether. So that is what we are trying to talk about. Now, in this scenario, I would always say that this refund and all those procedures are not going to be overnight because again, an assessment will come into picture. They will say that this is the value, these are the things that we can do, and this much is what we are expecting. So all those factors have to be included and then we can talk about the refund. Now, special damages also are called as the consequential damages, which may cover any loss by the breach of contract because of special circumstances or conditions that are ordinarily not predictable. Now, because there are certain conditions, there are certain scenarios which cannot be revealed on the spot. There might be a long-term impact or repercussion which I want you to cover up. Because the contract failed, in the long term, the company might get affected because of its brand value might go down, its image might go down, contracts might get affected. There are several, impacts that can happen altogether. So I don't want that impact and come and hit me. What I want in return is that please understand the consequential damages. Because of one failure, there is a series of consequences that's going to happen. So that's where I'm bringing in the special damages altogether. Now let's look at the special damages. There are actual losses caused by the breach, but not in a direct or in an immediate way. Now, for example, you break something. What are you going to do in the store? You will immediately pay that money and you will come out. Breakage charge, that's all. You're not going to give anything else. That's a direct effect altogether. But here, I'm not speaking about the direct effect. What I'm trying to speak is that the long-term impact that can happen because of the current situation, current breach that you have done. So in that case, what happens here is that to obtain the damages of this type of loss, what we do, the non-breaching party must prove that the other party, that's the breaching party, knew of the special circumstances or requirement at the time of contract was made. Now what happens here is that the other party has to be on the side trying to say that, sir, you should understand if you have broken the contract, what is going to be the far-reaching impact on me? What is going to be the stake on my side? That is very, very important. Now, for example, let's say that a particular company promised another organization that they will build their office within 2 years or 3 years contract. Now, all of a sudden, in between, if they break out of the contract, they breach it out, it is not just the office building getting stopped, but it is also an impact on the image of the company. It's also an impact on the business of the company, and it's also an impact on the human resource potential of the company. So what will happen here is that financially, morally, physically, mentally, the company is going to get affected. That's where I'm trying to bring in the special circumstances, the special damages. So while entering into the contract, the person who's trying to breach or who might feel that, yes, I can breach it away easily, should understand this consequences. Why? Because suppose if he goes ahead and takes a chance, then he might have to be penalized under the special damages. So that is why it is very, very important that when you study, when you enter into a contract, understand the long-term effects. You are not just signing a contract because you're going to make a near-term profit or money. You are signing a contract because there is some value behind it. The next thing, example, what we are trying to quote here, in a scenario above, a company A knew that company B needed new furniture. Absolutely yes, on a particular day, because its old furniture was going to be carted away that night before, and the damages of breach of contract would include the damages awarded plus the scenario. Payment of company's B's expenses in renting the furniture until the right furniture arrived. Now look at the scenario. Let's say that there is an inauguration function that's going to happen tomorrow. So by tonight, I expect the furniture to arrive and be in the place. So tomorrow morning when I'm inaugurating the building with my company staff, the building needs to look new, modernized and very good looking. Unfortunately, I receive a call saying that, sorry, we cannot be able to supply the furniture. Now that is not a simple thing for me to just forget it. Why? Because for me, it is not just the loss of furniture. It is a loss of image. It's a loss of renting it out again. It's a loss of, again, compensating the entire scenario. All these functional effects will start coming in. So that's where the company B will go and sue company A, who is supplying the furniture, saying that this is not an ordinary actual damage scenario, not a general damage. It's a special damage. You have spoiled my day and you have also made me to incur heavy loss because of this. So you have to compensate for all, not just for the furniture, but also for the cost and the inconvenience that has been taken up. Now, punitive damages. What is this punitive damages? Exemplary damages. We call the other word as exemplary damages are awarded to punish or for an example of a wrongdoer who has acted willfully, maliciously or fraudulently. Now this is very, very important here. This is a direct example of saying that if you do a mistake, you will be punished for it. So that's what we call it here as the making of a punitive damage altogether. Unlike the compensatory damage that is intended to cover the actual loss, punitive damages are intended to punish the wrongdoer. Now we are not getting into a compensatory mode. We are not going to get into a mode where I will just forgive you and forget it. I am getting into a mode of punishment, which means I want the person who has done the mistake to realize the mistake and let him go through the punishment. This is going to be a directive statement where I'm trying to tell you that if it is going to be something where I have found you guilty, where I have found you that you have done a mistake explicitly, that means you are going to be punished for it. So that is why we say that this is very, very important form altogether. Punitive damages are awarded in addition to compensatory damages. So not just the compensatory part, I can even put a punitive part on this, and I say that, boss, you have done a mistake, so you will undergo a compensation also plus a punishment also. This is like an add-on factor which we are going to give. So it is very, very important that you understand the entire scenario, you understand the entire circumstances before you get into the picture. Now, the punitive damages can be awarded in addition to the compensatory damages. So that is very, very important. Why? Because not just I don't want money, but I also want the person who has gone against me to suffer, to take the punishment. He should understand by doing this mistake, what is the problem here. Punitive damages are rarely awarded for the breach of contract. They may arise most in the case to punish deliberate or reckless misconduct. If there is something really seriously wrong, where something has gone wantedly on the side of the person, where he has created a complete havoc in terms of destroying the company or destroying the contract or making something malicious that could create personal, physical harm and all those factors, more of a criminal in nature altogether intentionally, then we are going to talk about this punitive, or else we don't want a punitive damage, we only want a compensatory so that the business comes back to normalcy. Now, how are compensatory damages calculated? Now, there are ways of calculating. Nobody is just going to accept a flat benchmarked figure on the paper saying that please give me this money. Nobody is going to go for it. So what do? We calculate the compensatory damages depends on the type of contract that we have breached and the type of loss that has incurred. Some of the general guidelines, we have a standard measure. We are not going to take it just like that, but we are going to have a measure. We are going to have an assessment here. We're going to go back and tell that person, based on these assessment, the damages are calculated. The standard measure of damage is an amount that would allow the non-breaching party to buy a substitute. The first thing is that to replace the loss. So whatever is the loss incurred, why is that loss incurred? What is the problem because of the loss? Will it cause some problem? Will it lead to some circumstances altogether because of which what is going to happen? That's what we are going to see here. And that is why if it is received, the contract would have been performed. So what we are trying to see is that because of bearing that loss, because of that loss could be overcome and taken forward, then we are going to talk about this factor. Then that's what we are looking into a standard measure. So by nature, by default, the loss that is incurred because of the breach, immediately compensate that much amount so that at least the contract is safe, at least the business is safe. The next one is that an important appreciation. Are there any limitations? Absolutely, we have certain things. An important limitation of the awards of damage is a duty to mitigate. What do we mean by the mitigate? The non-breaching party is obligated to mitigate or minimize the amount to the extent reasonable. Now, I know that you are affected. I know that there is a loss because of the other person, but that doesn't mean that we go on charging the other person. We have to be reasonable in what we are doing. So we cannot go back and say that, sir, you suddenly pay me $100 million as compensation. Cannot be accepted. You need to be reasonable enough so that you mitigate the risk to the less level possible, to the lowest level possible, and get at least the minimum amount done. Why? Because if you're going to charge up on the other party and if he starts going ahead and claiming a bankruptcy altogether, you might not be even able to get back that minimum amount. So it is very, very important that you understand how much can be charged, and based on that we can go forward. Damages cannot be recovered for losses that have been reasonably avoided or substantially ameliorated after the branch. So why we talk about this ameliorated is that suppose by default, by nature, there are certain things which has happened and that is inclusive. That's a part and parcel of that. Those damages cannot be recovered back. You cannot separately make an issue out of it and start claiming for that. The next factor is that the non-breaching party's failure for the reasonable diligence in mitigating damages means that any award of damage will be reduced by the amount so that that could be reasonably avoided. So what does the other party try to do is that they will try to find out, sir, what is the reasonable amount that you need to give me so that the business does not get affected. Because it is very, very common these days that, people will try to immediately claim innocence and say that, sir, I did not know about it at all. But that cannot be taken as a reason every time and said that, okay, fine, I will let you go. Since you have breached the contract, it is mandatory for you that at least you go back and give a basic compensation back to the party so that at least they are able to come back. So that is why we say that the reasonable factors, that is the non-breaching party, has to mitigate, find out a reasonable amount so that they are covered to the maximum level possible. With this, I come to the conclusion of the session. I hope and believe that all the information shared through this particular session will be of a great help and resource to you. In the upcoming sessions, we will be seeing more about the different factors of commercial law. But until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.